Bismillahirrahmanirrahim. Assalamu alaikum. Welcome to another lecture of revision. कानून शहादत ऑर्डर 1994 का इंडेक्स आज मैं रिवाइज करने जा रही हूँ। उसमें कंटेंट्स में सबसे पहले प्रीएम्बल पार्ट 1। इसके टोटल 3 पार्ट्स हैं। रेलेवेंसी ऑफ फैक्ट्स चैप्टर 1 में प्रिलिमिनरी, आर्टिकल 1 शॉर्ट टाइटल एक्सटेंट एंड कमेंसमेंट, 2 इंटरप्रिटेशन, फिर चैप्टर 2 स्टार्ट होता है ऑफ विटनेसेस, 3 हु मे टेस्टिफाई, 4 जजेस एंड मजिस्ट्रेट, 5 communication during marriage, 6 evidence as to affairs of state, 7 official communications, 8 information as to commission of offences, 9 professional communications, 10 article 9 to apply interpreters etc, 11 privilege not waived by volunteering evidence, 12 confidential communications with legal advisors, 13 production of title deed of witness not party, 14 production of documents which another person having possession could refuse to produce, 15 witness not excused from answering on ground that answer will criminate him, 16 accomplice, 17 competence and number of witnesses, chapter 3 है जी of the relevancy of facts, 18 evidence may be given of facts in issue and relevant facts, 19 relevancy of facts forming part of same transaction, 20 facts which are the occasion, cause or effect of facts in issue, 21 motive, preparation and previous or subsequent conduct, 22 facts necessary to explain or introduce relevant facts, 23 things said or done by conspirator in reference to common design, 24 when facts not otherwise relevant become relevant, 25 in suits for damages facts tending to enable court to determine amount are relevant, 26 facts relevant when right or custom is in question, 27 facts showing existence of state of mind or of body or bodily feelings, 28 facts bearing on question whether act was accidental or intentional, 29 existence of course of business when relevant, admissions 30 admission defined, 31 admission by party to proceeding or his agent etc, 32 admission by persons whose position must be proved as against party to suit, 33 admission by persons expressly referred by party to suit, 34 proof of admissions against persons making them or and by or on his behalf, 35 when oral admissions as to contents of documents are relevant, 36 admission in civil cases when relevant, 37 confession caused by inducement, threat or promise when irrelevant in criminal proceeding, 38 confession to police officer not to be proved, 39 confession by accused while in custody of police not to be proved against him, 40 how much of information received from accused may be proved, 41 confession made after removal of impression caused by inducement, threat or promise relevant, 42 confession otherwise relevant not to become irrelevant because of promise of secrecy etc, 43 consideration of proved confession affecting person making it and others jointly under trial for same offense, 44 accused persons to be liable to cross examination, 45 admission not conclusive proof but may stop statements by persons who cannot be called as witness, 46 cases in which statement of relevant fact by person who is dead or cannot be found etc is relevant when it relates to cause of death or is made in course of business or against interest of maker or gives opinion as to public right or custom or matter of general interest or relates to existence of relationship or is made in will or deed relating to family affairs or in document relating to transaction mentioned in article 28 paragraph a or is made by several persons and express feelings relevant to matter in question, relevancy of certain evidence for proving in subsequent proceeding the truth of facts therein stated, statements made under special circumstances, 48 entries in books of accounts when relevant, 49 relevancy of entry in public record made in performance of duty, 50 relevancy of statements in maps, charts and plans, 51 relevancy of statements as to fact of public nature contained in certain acts or notifications, 52 relevancy of statements as to any law contained in law books, how much of statement is to be proved, 53 what evidence to be given when statement forms part of conversation, document, book or series of letters or papers, judgment of courts of justice when relevant, 54 previous judgment relevant to bar a second suit or trial, 55 relevancy of certain judgments in probate etc jurisdiction, 56 relevancy and effect of judgments, orders or decrees other than those mentioned in article 55, 57 judgments etc other than those mentioned in article 54 to 56 when relevant, 58 fraud or collusion in obtaining judgment or competence of court may be proved, opinion of third persons when relevant, 59 opinion of expert, 60 facts bearing upon opinions of experts, 61 opinion as to handwriting when relevant, 62 opinion as to existence of right or custom when relevant, 63 opinion as to usage tenets etc when relevant. 64 opinion on relationship when relevant. 65 grounds of opinion when relevant. Character when relevant. 66 in civil cases character to prove conduct imputed irrelevant. 67 in criminal cases previous good character relevant. 68 previous bad character not relevant except in reply. 69 character as affecting damages. Chapter 4 of oral evidence. 70 proof of facts by oral evidence. 71 oral evidence must be direct. Chapter 5 of documentary evidence. 72 proof of contents of documents. 73 primary evidence. 74 secondary evidence. 75 proof of documents by primary evidence. 76 cases in which secondary evidence relating to documents may be given. 77 rules as to notice to produce. 78 proof of signature and handwriting of person alleged to have signed or written document produced. 79 proof of execution of document required by law to be attested. 80 proof where no attesting witness found. 81 admission of execution by party to attested document. 82 proof when attesting document witness denies the execution. 83 proof of document not required by law to be attested. 84 comparison of signature writing or seal with others admitted or proved. 85 public documents. 86 private documents. 87 certified copies of public documents. 88 proof of documents by production of certified copies. 89 proof of other public documents. Presumption as to documents. 90 presumption as to genuineness of certified copies. 91 presumption as to documents produced as record of evidence. 92 presumption as to genuineness of documents kept under any law. 93 presumption as to maps or plans made by authority of government. 94 presumption as to collections of laws and reports of decisions. 95 presumption as to powers of attorneys. 96 presumption as to certified copies of foreign judicial records. 97 presumption as to books, maps and charts. 98 presumption as to telegraphic messages. 99 presumption as to due execution of documents not produced. 100 presumption as to documents 30 years old. 101 certified copies of documents 30 years old. Chapter 6 of the exclusion of oral by documentary evidence. 102 evidence of terms of contracts, grants and other disposition of property reduced to form of document. 103 exclusion of evidence of oral agreement. 104 exclusion of evidence against application of document to existing facts. 105 evidence as to document unmeaning in reference to existing facts. 106 evidence as to application of language can apply to one only of several persons. 107 evidence as to application of language to one of two sets of facts to neither of which the whole correctly applies. 108 evidence as to meaning of illegible characters etc. 109 who may give evidence of agreement varying terms of document. 110 saving of provisions of succession act relating to wills. Part 2 has you on proof. Chapter 7 facts which need not to be proved. 111 fact judicially noticeable need not to be proved. 112 facts of which court must take judicial notice. 113 facts admitted need not to be proved. Chapter 8 has estoppel. 114 estoppel. 115 estoppel of tenant and of licensee of person in possession. 116 estoppel of acceptor of bill of exchange bailey or licensee. Part 3 last part is production and effect of evidence. Chapter 9 of the burden of proof. 117 burden of proof. 118 on whom burden of proof lies. 119 burden of proof as to particular fact. 120 burden of proving fact to be proved to make evidence admissible. 121 burden of proving that case of accused comes within exceptions. 122 burden of proving facts especially within knowledge. 123 burden of proving death of person known to have been alive within 30 years. 124 burden of proving that person is alive who has not been heard for 7 years. 125 burden of proof as to relationship in the cases of partners, landlord and tenant, principal and agent. 126 burden of proof as to ownership. 127 proof of good faith in transactions where one party is in relation of active confidence. 128 birth during marriage conclusive proof of legitimacy. 129 court may presume existence of certain facts. Chapter 10 of the examination of witness. 130 order of production and examination of witness. 131 a judge to decide as to admissibility of evidence. 132 examination in chief etc. 133 order of examination. 134 cross examination of person called to produce a document. 135 witness to character. 136 leading question. 137 when leading question must not be asked. 138 when leading question may be asked. 139 evidence as to matters in writing 140 cross examination as to previous statement in writing. 141 a question lawful in cross examination. 142 when witness to be compelled to answer. 143 court to decide when question shall be asked and when witness compelled to answer. 144 question not to be asked without reasonable ground. 145 procedure of court in case of question being asked without reasonable ground. 146 indecent and scandalous question. 147 procedure of court in cases of defamation, libel and slander. 148 questions intended to insult or annoy. 149 exclusion of evidence to contract answer to question testing veracity. 150 question by party to his own witness. 151 impeaching credit of witness. 152 question lending to corroborate evidence of relevant fact admissible. 153 former statements of which may be proved to corroborate later testimony as to same fact. 154 when matters may be proved in connection with proved statement relevant under article 46 or 47. 155 refreshing memory. 156 testimony to facts stated in document mentioned in article 155. 157 right of adverse party as to writing used to refresh memory. 158 production of documents. 159 giving as evidence of document called for and produced on notice. 160 using as evidence of document production of which was refused on notice. 161 judge's power to put question or order of production. Chapter 11 of improper admission and rejection of evidence. 162 no new trial for improper admission or rejection of evidence. Chapter 12 decision of case on the basis of oath. 163 acceptance of or denial of claim on oath. Chapter 13 miscellaneous. 164 production of evidence that has become available because of modern devices etc. 165 order to override other laws. 166 repeal. और QSO ये यहाँ पर कंप्लीट हो जाते हैं इसके कंटेंट्स। बाकी जो मेरा पूरी QSO का एक ही लेक्चर में 1 घंटे का ऑलमोस्ट लेक्चर है, उसमें ओवरव्यू मैंने पूरे QSO का किया है, वो आप सुन सकते हैं। उसके अलावा मेरे डिटेल लेक्चर एक एक आर्टिकल के ऊपर मुश्तमिल है, जो कि मेरी लेक्चर सीरीज़ चल रही है, अभी कंप्लीट नहीं हुई है, तो आप उसको भी सुन सकते हैं। और QSO जो है पूरे लॉ में सबसे ज़्यादा टेक्निकल और सबसे ज़्यादा इंटरेस्टिंग और सबसे ज़्यादा आसान लॉ है। थैंक यू सो मच फॉर लिसनिंग। फिर मिलते हैं किसी और लेक्चर में। अल्लाह हाफिज़।